economics. I lead the work on climate legislation and litigation at the Grantham with a wonderful team, many of who are sitting here in this room. And we work both on the monitoring developments in climate legislation and litigation, doing policy and engagement work, and also producing research that is hopefully useful not only as research, but also for practitioners, governments, etc. And I think this is very much how I see this panel that we are having today, a panel that has a lot of expertise from both the academic and the practitioner side, and some people with both hats. And we are here around a report in particular, but also to discuss more broadly important developments in corporate litigation in the climate arena. So before we start, I wanted to say that unfortunately, the main reason that we are here together is to celebrate Kim Bouwer's report. And unfortunately, Kim is unwell today, and she's not able to join her own party. So Kim will watch this video after. So I want to say that we are here very much honoring her hard work and grateful that she's put so much work producing this chapter, which we'll be talking about, which I highly recommend everyone reads. And we are really sad that Kim is not sitting here in this panel, but hopefully there will be many other opportunities for Kim to present this work. And then the second reason we're here, this is part of an important day that the BICL, the British Institute of International Comparative Law, is organizing around the publication of a toolkit that's led by Ivano Alogna. Ivano will sit here very shortly. He's lost somewhere, but he's so not Ivano, but soon Ivano. So with this in mind, I think we are already at time to start. I think we kick off when Ivano joins. You'll see him arriving, and we'll shift a bit the order of the panelists if necessary. And also, I wanted to offer you 20 minutes free of your day back to you. We will finish 20 minutes before the scheduled time because we don't have the main presentation of Kim. And I think everyone can do with a bit more time in their days. So that's for free. I'm giving you back. But what we have here, I'm sure you will enjoy. We had a prep call for this event, and the prep call was just fabulous. So I'm glad that I'm not the only one who had a chance to listen to these amazing experts in the prep call. You will have a chance today too. Small audience allows for questions, so please feel free to address them and ask your questions. It's not always that you have such a distinguished panel here available to you. So please do think about anything you want to ask them. I'm sure you can answer. So very brief introduction to what we're going to do today. In terms of the topic, this event, Corporate Climate Legal Tactics, a closer look at the UK, as I said, is part of a larger BICL project that Ivano will tell you about. In terms of where corporate climate litigation sits in, I think it's important to situate this in a much bigger picture of climate litigation in general. So corporate litigation doesn't exist isolated from general litigation. It's part of this bigger story, but is one that, although much smaller in number, the majority of cases is still litigation brought against governments. Litigations against corporations have grown in interest, attention. Count the number of headlines, the proportion between the headlines on corporate litigation is going to be much larger, but don't think that it's the majority of cases. Why is it so important? Well, our panel will clarify and enlighten us a bit on that, but while it attracts attention, I would say we still need to understand better what this is, how it works, when it doesn't work, how it can work better, how it can involve different corporates, different strategies. And I think this report does a great job in guiding a lot of, I would say, future litigation. There's been a lot already, but there's scope for much more. So the project that BICL has done is a project that looks at 17 jurisdictions. So here we're talking about the UK, but there are 17 jurisdictions in total with similarly robust reports. I was part of the Brazilian report, so I can attest for that, and I've looked at a few others. And I was just speaking to Estelle, I would say one report gives you a lot of information, a wealth of knowledge in terms of the legislation and what potential litigation can happen. If you have the chance to look beyond, I'm sure you will get also many different facets of this phenomenon across the world. So that's enough for me for now. I want to introduce the speakers. And as I said, in a slightly different order. So we are going to start, instead of Ivano presenting the project, I want to start inviting Paul to begin. And it's really an honor to have you here. I don't think we ever had you at the LSE, have you?
No, I don't think so. It's my first time. Thank you for having me.
First of many more, hopefully. Thank you so much for coming. Paul Benson is a senior lawyer at ClientEarth. Before, he worked in private practice, and I have to say, looking at our CVs, all of us have at some point worked on that side. Kim has, Megan has, Mark? Still, yeah, counts, not big corporates. I think all of us, and myself too. So we all at some point had that experience. At some point we broaden our universe to work in other practices, and Paul has been leading really important work at ClientEarth. He's the brain of a lot of the strategic litigation that takes place there, in particularly one of the cases that we'll be discussing today, the Shell against ClientEarth against Shell Board of Directors, and many other cases. So thank you for joining us. Then in the order, we'll hear from my notes here, Stuart will follow. And Stuart is a partner at Setzer with experience on pension and a bit on integration also of climate in ESG. So Stuart, I think when we had the call, you said you were afraid of being with this hardcore climate lawyers around you, but the beauty of this area of practice is that climate law doesn't quite exist by itself. It needs all of that. So, you know, the corporate law, the pension, and you come with a lot of interesting knowledge on that. Then we will go to Mark, and Mark with us is KC at Garden Court Chambers, specialized in planning, environmental, human rights, and beyond. He's instructed several groundbreaking cases, many of those that are still ongoing, the Klientnationen versus Switzerland, Duarte Agostinho against Austria and 32 states, and many other exciting ongoing cases in climate that we'll be also covering. And last but not least, Megan, colleague here from across the road, Professor Megan Bouwer, Bowman, Professor of Law and Director of the King Center for Climate Law and Governance. Also qualified barrister, solicitor, worked as a practitioner in Australia, and now has this, what I call the privileged position of looking at what's happening and commenting, but also having interaction in practice. That's all for me. I've introduced our panel, and I want to invite Paul to begin.
Thank you so much. Thank you, Joana. And it's a real pleasure to be here, so thank you for the invitation. I'm going to hone in, if I may, on two particular strands of cases that I dealt with in Kim's really quite brilliant overview, I think, of corporate climate litigation in the UK. And the scope of that report is obviously quite broad, and I think what Kim really draws out very well is the fact that there is litigation on foot, or has been litigation over the last few years, which really directly affects corporates and multinational companies, but it might not be commercial litigation in the sort of true sense of that term. And a good example of that, I was pleased to see Kim referencing, was our action against the FCA, the Financial Conduct Authority, where there was no corporate party as a defendant, but of course that related to Ithaca Energy PLC's prospectus, and what we alleged was an insufficient and inadequate disclosure on climate risk. I sort of jumped into that case as a reference point, but I think that's just an example of the way in which certainly public law actions, judicial reviews, our case against Drax from a few years ago would be another very good one, or judicial review, I should say, not against Drax, but where Drax's proposed plant was directly affected. And so what you see is a suite of proceedings which directly affect corporate actors, even where they are occasionally not even a party to those proceedings. But the two strands of case that I just wanted to start to develop in this brief overview was, of course, the case that I led on behalf of ClientEarth against the Board of Directors of Shell for climate risk mismanagement. That was the first case worldwide to seek to hold company directors liable, personally liable, for failing to adequately manage the risks of the energy transition. And those were the risks not to the world, inhabitants of the world. There was no sort of moral or ethical element to the litigation brought. It was very purely a financial risk to the company. And it has been indeed well accepted in the industry among business and central banks across Europe that climate change presents huge risks to companies like Shell, companies in high emitting sectors, and indeed the entire global economy on a systemic basis. And so that was the context of that claim. And what we alleged in the litigation, and I should say that we brought the litigation as a shareholder of Shell. ClientEarth has been a holder of a very small number of shares, as you can imagine, of Shell for many years, and has engaged with the company on that basis. And has never received what we felt to be an adequate response to the concerns that we and many other investors had about the way in which climate risk was being managed at Shell. Of course, for a company like Shell, whose business is so centered on fossil fuels, when you have a situation where the International Energy Agency is forecasting in every single energy transition scenario, irrespective of whether it is fast-paced, slower-paced, volatile, smooth, forecasting a decline, in demand for those products, how is Shell as a fossil fuel company going to manage that risk? And that was the sort of context of our claim. Now, I can speak for a very long time about this claim. It's very close to my heart, so I will endeavour to keep this relatively brief. But the long story short, our claim was dismissed by the High Court initially on the papers at the permission stage, because we were seeking to step into the shoes of the company effectively to pursue alleged wrongdoing by the board. There is a sort of filter stage that the court employs to decide whether the claim should proceed. The court decided that the claim should not proceed for a variety of reasons, which I'm more than happy to develop as we continue our discussion. And the Court of Appeal, I think very disappointingly and unfortunately, refused us permission to appeal that decision. I should note that the decision has been pretty heavily criticised since it came out by a number of eminent barristers and indeed by a former Justice of the Supreme Court, Lord Carnworth, who, of course, not only carries all of the legal weight that is and credibility that is due to him as a former Justice of the UK Supreme Court, but was also chairman of the Law Commission at the time when the Companies Act was formed. And it was the Companies Act that we were relying on in those proceedings. And he was relatively critical of the judgment and felt that it was a missed opportunity for the court to look at this issue more closely, engage with the evidence and allow the claim to proceed to an examination of its merits. And certainly we felt the same way. We felt that it was a missed opportunity. So that's one claim, which, as I said, is very close to my heart, and which I'm very happy to take any questions on as we proceed. And the other area of litigation, which I just wanted to sort of refer to in this opening, was climate tort litigation, which is often referred to as the sort of holy grail of climate litigation. And I wanted to reference there briefly the Smith-Fonterra case in New Zealand, which some of you will be familiar with, because I think it is really quite an important development there, in that the New Zealand Supreme Court has recently allowed the claimant's appeal in that case against a strikeout of his claim against 7 high-emitting companies, not seeking damages, I should add, but rather seeking declaratory and injunctive relief. And for those of you who are not lawyers in the room, I suspect that is actually quite a small number. But what I mean by that is that the claimant in these proceedings is seeking against these 7 high-emitting defendants in New Zealand a statement, a legal statement, a declaration from the court that they have acted in breach of various duties under tort law, and is seeking an injunction, an order requiring those defendants to take certain action. And the action that the claimant seeks in those proceedings is that the claimants reduce their greenhouse gas emissions effectively. And you see that played out across different cases of this nature. Similar remedy has been granted in the Netherlands in the Milieu de Foncy litigation against Shell, which is of course one element of our claim then against the board, because Shell was ordered in the Netherlands to reduce its greenhouse gas emissions by net 45% by the end of 2030. And one of the allegations that we made in our claim was that the board of directors was not complying with that court order. We effectively submitted to the court an extraordinary course of action for a board of directors to take to ignore an enforceable court order. But I will pause it there. We have a number of other wonderfully eminent speakers who can speak to other issues, but that's a bit of a starter for 10 on some climate litigation cases that are close to my heart or have caught our interest at ClientEarth.
Thank you so much. Very good start. And now we have Ivano joining us. So if you don't mind, before we continue, I think it would be useful, Ivano, if you provided some context about the toolkit and just kind of telling everyone about it. Let me introduce you. Ivano, Dr. Ivano Alogna is the research lead in environment and climate change law at PLICO, the British Institute of International Comparative Law, and he is the mastermind and the person who made all of this big effort possible. So I don't know if everyone here knows about the toolkit and the project, so you might want to share a few words.
Yeah, absolutely. So good afternoon, everyone. Sorry for the delay. This was caused by some, we finished this morning our launch, the public launch of the Global Toolbox on Corporate Climate Litigation. So the Toolbox, it's a comparative project that we started last year in September 2022. So we are in the second phase, we are in the dissemination phase. Today we just presented in itself the Toolbox. You can go on the BICL website and see a collection of legal models, decision, the common elements that we find in each kind of causes of action, procedure, the remedies. And we're working on, for the first part, we work on 17 countries. If you go on the website in this corporate climate litigation platform that we created, you will find also the 17 national reports that have just been published in the last week. We finished with the Norway one. So we have really great reports from really great groups of experts. They are led by people like Jackie Peel in Australia, Mark-Philippe Weller in Max Planck in Heidelberg. We have, in a way, very young, but also very established professor leading this kind of reports. But on the other side, we have also a community behind that. For each country, we have practitioners, judges, we have other academics working on different topics that can, in a way, create this cross-fertilization of concept of ideas coming from, for example, different kind of litigation. And so with the Toolbox, what we try to do is really to raise a little bit the knowledge on this kind of litigation, corporate climate litigation, because we want to stress out the fact that it's not litigation against the companies, but it's litigation involving companies. I know that seems like subtle, but in reality it's also the fact that you have many slap lawsuits in this moment. So they are sometimes also the claimants or the plaintiffs in some countries. And well, what we have done so far is just the beginning of this work, because what you will find on the website is on all these. There are 29 sections, as I said, divided in causes of actions, procedure and evidence remedies. Here there are two of the other masterminds, two of our researchers from Bicol, Anthony Wenton and Crisela Bernardino. So we have a team from people that is working on this day and night, but we try to, take use of the collective intelligence, harness the collective intelligence. We're putting together, and that will be done in the next months, because we are going to organize European, African, Asian, Oceania, and American summits, where we put together all the different constituencies, all the different rapporteurs, their groups together to discuss. And we're going to add also more countries. So if you were thinking, oh, I'm from Peru, or I'm from, I don't know, Switzerland, why don't see my country there? Because it happens to me a lot. Yes, we are going to do that. Yeah, we have to start from somewhere. So 17 countries with at that time were the country that had corporate climate litigation. And now with the new National Conference Regional Summit in particular, we are going to add more countries. We were going to have more rapporteurs and group of people. So this is the first conference, and we are going to make one for each country. And I'm really thankful to Joana, to Kim, and to these wonderful speakers that are also part of the international expert group, at least the group for the UK, that contributed to our work. So yeah, I'm really grateful for all this. And I think I stop here because it's already short. Thank you very much, everyone.
So thank you. Now you have the context of the report. You had already Paul's insights into some of the cases, and I want to invite Stuart to now bring his introduction. Thank you.
Thank you. So I'm afraid we're about to detour sort of rapidly into a world that may or may not interest you, and this is pension funds. For anyone who switches off, I will ask that you be woken up once they're finished. As I started, I might just ask for a show of hands, and apologies, this won't include those online, but who has any knowledge at all about pension schemes and how pension trustees operate or anything else? Okay, so there's a bit, right. I'm going to start at the beginning because I think this sort of might be helpful. When we're talking about the sort of the duties of pension fund trustees, it's important to understand the context in which they're operating. So essentially you have two types of two types and then two subvariants of pension schemes. You have contract-based pension schemes. So that is what I have. I've got an Aviva pension scheme. I've got a contract with Aviva. I select a fund to invest in, and that's just a personal contract between me and Aviva. There's no trustees involved in that sort of arrangement. So that's a contract-based setup. Trust-based schemes are the ones that we tend to talk about more often. They're the ones where there's a board of trustees and they look after collectively the assets of the scheme for the benefit of the fund's beneficiaries. And there are two types of trust-based schemes. Actually more complicated than this, but for now, for these purposes, there's two types. There are defined benefit schemes and there are defined contribution schemes. Defined benefit schemes are those where there's a great big pool of assets not owned by anyone, not owed to anyone in particular, but is there in order to pay a defined level of benefits to the members when they come to retirement. You'll hear these referred to as final salary schemes or career average schemes. They're all a variant on, there is a formula that calculates how your pension is put into payment and the amount, usually based on length of service and how the clients get the salary and that sort of thing. That's defined benefit. Defined contribution schemes are completely different. It's almost like a bank. Each member has their own pot of money, and although the trustees are looking after all these little pots of money for the benefit of members, each member's sort of pot of money is invested and will provide a hopefully bigger pot of money when they come to retire, and then the member chooses how they use that pot to buy an annuity or buy a Lamborghini or whatever they want to do. So why am I telling you all this? I think it's important when we start looking at the duties of trustees when it comes to put those into context. So firstly, to understand when are we talking about trustees versus when are we talking about an insurance company that just happens to have a contract provision. And if we're looking at trustees and what they're doing with all these assets that they're sitting on and investing, and whether they're doing enough to take account of climate issues and the way they're investing, you need to look at the purpose for which those funds are being invested. Are they being invested to grow a pot of money for a group of individual people? Or are they being invested to provide a giant bucket under which all these defined benefits are going to be paid out for all the members of the scheme over the lifetime of those members, in which case you get lots of sort of cross subsidy potential. So, sorry, that's the boring background to pensions. Let's move on to what the actual duties of those pension trustees are. We also talk about fiduciary duties, and I'm always slightly nervous when talking to a room like this, because in private practice, I'm sorry, I think probably the only one who hasn't had the imagination to leave private practice. I'm still in but we sort of talk at private practitioners get all the law wrong, but we tend to get all our clients payers for it. But we talk about the fiduciary duties of trustees. When I previously talked to an academic group, I was shot down because nothing I was talking about was actually fiduciary duties whatsoever. They were trust law duties of fiduciaries, which is quite a different thing because the remedies are different. But let's put that aside. When I talk about fiduciary duties, what we really mean is what are the trusts-based duties of pension trustees. And you will hear people say, well, it's to act in the best interests of the beneficiaries, or maybe at the other end of the spectrum, it's to provide the best risk-adjusted return for the members. They're both completely wrong. Neither of those work. If you want a good paper, and I'll perhaps put a link around in the notes afterwards, there's a very good paper by David Pollard at Wilberforce Chambers on best interests not really being a real legal duty at all. It doesn't really work for pension trustees to talk about investing best interests. I should warn you, it's about 170 pages of why the best interest duty doesn't work, but it is an excellent paper and a really good sort of tour de force going through all sorts of different cases about trustee best interests. Maximising risk-adjusted return, that's very old-fashioned. That's what people used to say sort of back in the days of Cowan and Scargill, or following it. And I could dissect Cowan and Scargill and tell you why it doesn't mean that trustees have to invest to maximise risk-adjusted returns or anything else. But it's probably not the time to do that. But again, I can sort of share some notes on why that doesn't work either. So if they're not the duties, what are they? I've always said they're a bundle of duties, essentially, like most things to do with trust law. You can't point to one thing and say that's what trustees have to do. They're subject to a bundle of duties, which at its heart are probably three elements. The first is to exercise their powers under the trust for the purposes for which those powers were intended. Now, these are trustees looking after a defined benefit scheme or a defined contribution scheme. So they have to invest the money given to them for the purpose in a defined benefit scheme of paying out these defined level of benefits, or in a defined contribution scheme for growing members' pots to provide a retirement income for those people. So core duty number one, exercise the investment power for the purpose of paying those pensions. Core duty number two is when making any discretionary decision, trustees need to take account, and this is a completely useless explanation, but they're supposed to take account of all relevant factors and put aside any irrelevant factors. That doesn't help you at all. But when we talk about if the purpose of the investment power is to provide members' pensions, then factors that are relevant to that will be those that are usually financial. And really, when you go back to the 1980s case of Cowan and Scargill, although it did talk about sort of maximising returns, really that was a proper purposes case and a relevant factors case. And then the final bit of the bundle of duties is to exercise powers in accordance with the prudent person test. So that means you're not supposed to put it all on the Rule 30 of Chepstow or anything else. So you have to take a prudent approach to how you're investing money on others' behalf. Where does that leave us in terms of climate? Well, none of this changes the purpose of the trust. Trustees still have to invest to pay members' pensions. So in that sense, all of the developments we've had over the last 5 or 10 years in terms of pension schemes getting more climate aware, nothing has changed in terms of their fiduciary duties. What has changed is that second element, that what is a relevant factor when exercising investment patterns. And it's become very clear, and some of us, myself included, have been saying for a long time, that transition risk, physical risk of climate are highly relevant to the financial performance of your assets. But that's how you get there. You can't look at the trustee board and say, you've not properly taken account of climate-related risks, and that's a breach of a best interests duty. It doesn't work. What it is they've not properly directed themselves by considering all relevant factors. So that's how you sort of should look at the trustee duty. I'm conscious I could talk for hours on this. I could use the 15 minutes we've got spare, but I wouldn't be thanked for that. So just to sort of bring us up to date, this has been looked at by the Law Commission on a couple of occasions, back in 2014 and more recently. They did an analysis of the fiduciary duties of investment intermediaries. Again, this fiduciary duty references, so it's good enough for the Law Commission, it's good enough for me, even though I'm told they're not actually fiduciary duties. They looked at the sort of, went through a similar analysis and said, well, relevant factors are really those that are financially material, and environmental, social and governance factors should be considered within that frame of reference. You can consider anything that's an environmental factor or social factor or otherwise, as long as you can say it's financially material and therefore a relevant factor to the investment performance. You can't consider issues that are moral viewpoints of your beneficiaries or even the trustee board, or ethical viewpoints where they are not financially material. They are in the Law Commission's wording, non-financial factors. Now, personally, I think that distinction of financial factors and non-financial factors is really, really unhelpful. I much prefer to talk about relevant factors and factors that are not relevant. And that brings us up to date. So I was involved in the Financial Markets Law Committee, worked on the duties, which published a paper a month or so ago now, mid-February. That has been touted around by different people as, this is groundbreaking. It doesn't, none of this changes the fiduciary duty. The fiduciary duties are exactly what I've just described before. However, what that FMLC paper has done, I think, is provide a real endorsement for the fact that climate-related risk is squarely within those relevant factors, those financially material factors, and really should be taken account of by trustees when exercising those investment powers. Not because it's the right thing to do for society or the planet or anything else, but that's just part of the duty of investing prudently for the benefit of your beneficiaries. There are some other things. There's all sorts. The FMLC paper is really good. It's one of those papers that you have to read several times. At first pass, you sort of don't feel like you've got anything out of it. But there's quite a few little Easter eggs in there, and there's a couple that really interest me. Maybe we might pick up on some of these later. But one of them was to do with how you address systemic risk of climate change. All that stuff I've been talking about and all the stuff that traditionally pension trustees don't do is they look at, well, we're investing in this. Actually, they don't do this at all. No pension trustee says we're investing in this particular company. We're going to look at the climate risk attributes of that particular company's business model. Pension trustees appoint a fund manager to do that on their behalf, but they should be sort of scrutinising that. But regardless of whether trustees were doing it themselves or sort of acting through an investment manager, you're still narrowly looking at the attributes of the entity in which you're invested in, saying this coal mining company has huge stranded asset risk. That's financial risk to us. That's a financially material factor. We think that's not a great thing for us to invest in. That's sort of the traditional way of looking at it. But none of that addresses the system-wide risk. The climate risk is going to sort of drag down all of your investments. Unless it's tackled properly, and unless we have a sensible sort of transition to net zero. And the Law Commission, when they looked at this in 2014, there's again a sort of slightly unhelpful line in there that talks about the extent to which trustees can look at market-wide issues. And what the Law Commission said was yes, that's financially relevant. The problem you have as any given trustee board is that you're too small to make a difference. Your pot of assets aren't going to move the dial on these market-wide issues. Therefore, it's probably a non-financial matter. Sorry, going back to that unhelpful financial versus non-financial, but that's how the Law Commission looks at it. Therefore, it's non-financial, therefore you can't really take it into account. Sorry, side note here, there is a legal route under which you can take non-financial factors into account, but it is almost impossible to achieve. And I think you'll see most pension lawyers say it just doesn't really work legally or practically. So I'm not spending the time on that. So anyway, that's where we were sort of left by the Law Commission. What the FMLC paper does, it hasn't explicitly said, oh, that was wrong, but it did say, and again, this is one of those things you wouldn't spot at first pass, but if you know the background, it's quite helpful wording. There's a paragraph in the FMLC paper that says, you know, trustees should think about climate and everything else. And those issues that may once have been thought too remote and insubstantial may now not be so. That's a sort of veiled reference to trustees thinking about systemic risk in a way that is slightly different to the narrow view that the Law Commission put over 2014. I think that's really helpful. And there's further commentary on systemic risk as well, how trustees should look at, and FMLC paper is explicit in saying you can't just look at the risk attributes of a particular investment or a particular fund. You have to look at portfolio market-wide. So I think all of that's helpful. I still think we are not quite there in terms of those fiduciary duties allowing trustees to tackle systemic risk in a way that might, on the narrow view, reduce return or increase risk in the portfolio on a sort of leap of faith that if we all do this, that's going to be better, you know, collectively for our investments. I think there's still a little bit of work that's needed there, and that's something I'm personally very interested in. But anyway, FMLC sort of nudges us up to the line on that, and maybe not any further. I should probably stop now, but just one footnote. There has been a lot of pensions regulation over the last 5 years. I'm not going to say that's totally irrelevant. It's highly relevant, and it's done a lot to get trustees engaged in the topic. But predominantly, you need to think about the pensions regulatory environment as being, when it comes to climate and other ESG factors, as being one of disclosure. So large funds now have to do TCFD reporting. They have to include commentary in their statements of investment principles, which are publicly available as to how, as to the trustees' policies on environmental, social, and governance factors, and they have to do annual reporting on their stewardship activities and how they their stewardship policies. But all of that's reporting. None of that's sort of tangential to the fiduciary duty and maybe an important context or backdrop, but it's not. You can't look at the regs to extrapolate what the trustee duties are when it actually comes to how they invest their assets. Sorry, that was a real whistle stop through pensions. Hopefully that would have been of some passing interest to you.
Thank you, Stuart. Stuart, so good. Yeah, I mean, you know, I don't envy you. Pension lawyer is not the most, as Kim would say, sexy area.
I don't know what you're saying.
But it's a very important part of the story. You know, it's what you said about climate being a systemic risk, and how if you want to change the system, you need to address the system from all the different ends. And of course, the fossil fuel companies are obvious, but the pension funds and those who make the decisions are also part. So you know, you are acting in an important part.
One thing I sort of didn't really have time to cover, but maybe we might come on to, is the sort of litigation risk around pension schemes. You know, that what is the role of trustees to bring climate litigation in relation to the entities they invested in? And the thing that terrifies me, what is the risk that trustees themselves could be subject to litigation for not doing enough? On the latter, it's a really high bar, and I think it's probably a bit of a dead end in most cases, simply because the role of a trustee is to, so it talks about fiduciary duties, but essentially it's a discretionary power as to how you invest the scheme's assets. And unless you've kind of acted so unreasonably or completely misdirected yourself, the likelihood of trustee personal liability there is vanishingly small. But anyway, maybe.
They're fighting words, Stuart, aren't they? Really? I mean, there's something that, not to break ranks when you do speaking out of turn totally. But I mean, that sounds to me like a very similar argument that Paul was running in his case, but in a different context of directors. So I would caution against such strong language.
Well, I think the role of trustees is different to corporate directors. But and there have been attempts to make trustee. Well, there has been one notable attempt to make trustee directors personally liable, which really didn't get anywhere.
Thus far.
Well, this we can't have a debate.
Well, this is, yeah, good.
That's not to say trustees shouldn't be doing stuff, and actually, the pressure needs to be brought to do that, to put it behind that. But the litigation side of things, not quite so good.
Mark.
Yeah, can I ask a question? And so what do you think that might be that, what is the element that can change this dead end from the point of view of litigation, climate litigation?
So I think you probably need to, what we found sort of moves the dial is getting trustees engaged in the topic, not by sort of suggesting that they're going to be personally liable for having made bad decisions. Although what I talked about before is the sort of defined benefit, defined contribution distinction. That's really important because in defined benefit, it's quite hard to demonstrate financial loss because your pension is still the same. The returns on the investment might have been slightly lower, or you introduced additional risk, but still getting the same pension. So that that was one of the issues USS case. But I think what in my mind, what's needed is trustees sort of need to be sort of encouraged to do more, and regulation can push them or require them to do more. That's probably more productive than the sort of stick to beat them with not doing enough. And I think trustees also need to play a bigger part in stewardship in relation to the companies they're invested in, and taking a more active role in climate litigation and shareholder resolutions and all of that stuff. So sort of trustees on supports for good rather than necessarily doing.
As you would expect, I am trying to have some views on this. I think we should move to Mark. Otherwise, we will indeed take up probably the rest of the evening as well.
Well, good afternoon, everybody, and thank you, Joana, for the introduction, and thank you for his contribution. And Stuart, it may not be sexy, but it's important. I want to know more about my pension, and I want to make sure that the trustees are doing a good job in terms of investing any money that I put into it. Not very much, but it's important. And you've kind of uncovered a world that really I know nothing about in discussing it with this audience. What I was going to say is that my thought process, and I'm not a pensions lawyer, but is that trustees, when looking at systemic risk, who don't look at the correct figures and don't look at the correct modelling on where we're going and where we need to go in order to hit 1.5 degree, although 1.5 degrees is a dangerous temperature rise. But if we don't have the correct modelling that we look at as pension trustees when we're working out whether or not to invest, and we invest in stranded assets, then I would have thought that the trustees may well be in a position where they will be liable and personally liable. But I'm not a pensions lawyer, so maybe I'm wrong about that. Maybe you can tell me, and perhaps Paul can tell me whether or not that's a possibility. I'm going to go back to the report, if I may. Can I begin by thanking Kim and the team, some of them around me, some in the audience, who've done a brilliant job in creating such a comprehensive, thought-provoking and clear report on the corporate litigation world, parallel universe to me, to the one I inhabit most of the time, I have to say, but a really clear and thought-provoking report. And also to Bickle for all the work in the background, behind the scenes, and I see that Jane somewhere, she doesn't want to be mentioned, but she's going to get a mention, and her team, Anthony and others, and obviously Ivano, who's been marshalling it all. Because it's part of this global toolkit, which I was very happy to be at the launch of this morning. And it was a wonderful event. You squeezed in so many presentations from so many different parts of the world. covering all the topics in the global toolkit, and it's just the go-to place for me now when it comes to thinking about corporate litigation. As I said, has been up till now a bit of a parallel universe. Although I have to say that there are some cases I've been involved in where corporates have been there in the room. Stella and I have done a lot of work against fracking companies and oil companies, and in the Finch case where we're waiting judgment, in the room as a respondent was Horse Hill Developments, the oil production company, very keen to fight their corner. In fact, fought it as hard as they could. And so these cases, I think, are called first generation cases by other authors of other reports. The Australian report, for example, Jackie
US.
talks about,
Yeah.
and the US.
Yeah.
And as I think Ivano may have been saying, it would be really useful for anybody looking at the UK report, but then if they've got time to look at the other reports and see the comparative work that's going on, because in the Finch case, Estelle and I were presenting as we went through the different stages of the appeals, comparative law from the US, from Australia, the judgment of Chief Justice Brian Preston, one of the authors of the Australian report, in one of the cases that he decided, the coal mine case, and also the Norwegian case. Albeit I got a very short shrift when I raised it in my short presentation. Estelle did a lot of the work in the Supreme Court, and very well she did too. But since that hearing we had in the Finch case, there's been a more recent decision by the Ultimate District Court, and this is all about downstream emissions, whether or not, as you probably all know, whether or not a decision maker in the UK, but this will have wide implications if we're successful, needs to take account of downstream emissions when carrying out an environmental impact assessment. And so first generation corporate case with a big potential to move the dial. But there's these next generation cases, and I feel like I'm talking like somebody who's a Star Trekky fan, but a next generation case where cases will be brought against, dare I say it, your clients, possibly not, the pension trustees, but the investors, the banks, the World Bank perhaps, corporates themselves. That's what I'm actually really interested in, having read these reports and the global toolkit. And you know, ideas are whirring around in my head, and I'm not a corporate lawyer. So, I mean, there must be a huge amount of imagination out there that can be tapped into and provoked by these reports. What I was going to say is that flying into that parallel universe with the carbon neutral global toolkit as my carrier, as it were, I was talking to somebody, Rodrigo, about the possibility of torts being brought on behalf of animals as opposed to humans. Who knows? I mean, we just won a case in front of the Privy Council called Mussington against the Antigua and Barbuda government. And in that case, in a judicial review, in an environmental judicial review context, the Privy Council were really clear to have standing in order to protect the interests of flora and fauna, biodiversity, red-footed tortoises, Barbudan warblers, and so forth. All you need to do was be somebody who has a keen interest in bird watching, or perhaps a fisherman concerned about fish. Now, if you can do that in environmental judicial review, why can you not bring a tort claim on behalf of, for example, the fish that are swimming down our polluted rivers, the jaguar we were talking about in the Amazon, against one of the polluters, against one of the investors, possibly against the pension trustee.
I'm ready for the discussion.
In our pre-con, we said we would be meeting. You're on board. But this, I mean, perhaps I've gone beyond the next generation. I don't know, but it's just so thought-provoking. You know, the UK report and indeed all the other material, and that's really, I think, the beauty of it for somebody who comes to the project as somebody from that other universe, the environmental and climate justice universe. And I think we can bring the skills we've learned from that one universe to another, and combine perhaps with some corporate expertise, and possibly bring some cases which nobody had really thought about, perhaps corporates may not be prepared for. And the threat of that, at the very least, is something that I thought perhaps some of those big firms and solicitors who advise their corporate clients will want to tell them about, because it might make them their clients make a difference and change their behaviour. So thanks again to Kim and the team, everybody at Bickle, the researchers and all the team for giving us the inspiration in this report and the global toolkit to think outside the box.
Thank you.
Thank you. Okay, good. Thank you. So, the sort of framing and focus that I want to focus on is to really tease out something that's had just a little bit of attention so far, but it's the regulatory perspective in the context of litigation. So I really kind of want to, and something genuinely interesting actually, is the dynamic interplay and interrelationship between litigation and regulation, topic that the legal toolbox really, but certainly this UK chapter, King's UK chapter, goes with. So, and I really want to focus on that for three main reasons. First of all, the very nature of strategic climate change litigation, the fantastic work Joana and Kim has done on the nature of it, which is, of course, the purpose to influence policy and behavioural change more broadly and beyond the parties directly involved in the suit, and just as importantly, beyond the outcome of the decision. And we haven't talked about that explicitly yet. We do tend to, I think, as lawyers, get very focused on who wins and who does not. And I think in this space, and I really think, Paul, you know, I've mentioned this to you before, but the ClientEarth and the Shell case is a perfect example of the discussions taking place in a number of fora amongst multiple people who had nothing to do with that particular litigation, that's keeping some people awake at night for both good and troubling reasons. So the effect of litigation on the regulatory environment, but also the effect of the regulatory environment on litigation, because you know, if we're talking about company regulation, financial regulation, you know, there's a lot of new and emerging law and regulation coming through in those two spaces, in the UK and in the EU. And as we know, a lot of that EU legislation, particularly I'm thinking of the reporting directives, are going to implicate UK businesses. They do have an extraterritorial reach. So right and wrongly, so you know, Brexit hasn't stopped that from happening. So these things I think are fascinating. The second reason I kind of want to focus on that is the pluralistic nature of the space. So I really see enforcement and accountability as a very broad church. You know, we see those two things manifesting in multiple regulatory spaces, involving multiple different actors. And I think the question really is the relevance of enforcement outside of the courtroom. Other adjudicatory spaces. So Paul mentioned the Ithaca case, although that was in a courtroom admittedly. So I guess I'm thinking more of actually ClientEarth complaints that were brought in sort of 2018, 2019, 2017, around that time, pretty early in the scheme of things, complaints that ClientEarth brought to the FCA against a suite of companies, known as insurers, about their complete and utter failure to disclose climate-related risks to their business. The argument being that, particularly for insurers, climate risk is material. How can you not even mention it in your report? And that was early on. That was pretty groundbreaking stuff. So that did happen outside of courtroom. That was through a complaints procedure. And that was before even the suite of regulation and legislation that we now have on that topic. So, you know, other adjudicatory realms, but also what happens intra-firm, you know, between the corporate governance actors within the firm, between the shareholders and the directors, between the directors and the directors. Management in there and you know, there have to be a German family employees as well. So these spaces I think are fascinating for really sort of investigating what's going on. And I think also if we look at this dynamism between regulation and litigation, we also get a little bit of a sense of the direction of travel. So that's where I'm going to focus. And I'm really going to sort of focus on two main topics, I think. I think the place I really want to begin is the advent of something that we haven't mentioned at all, really, but I think was very much in the ClientEarth case forward, is the advent of transition plan regulatory requirement, right? So in the UK, in October last year, so we're pretty new, right? We've just got the transition plan task force framework released, which focuses on transition plans for firms, grouped into the categories, helpfully, of ambition, action, and, wait for it, accountability. So it is a regulatory guidance. It's voluntary at this point in time, but I would say, you know, similar to the approach that we've actually had with corporate reporting and disclosure, TCFD, it's only a matter of time before it comes. And we have precedent in other jurisdictions for the mandatory nature of transition planning. I'm thinking particularly of the energy and climate law in France and Article 29, which, interestingly enough, sort of isn't framed as a transition planning article, but has the effect of it because it requires firms to report on double materiality, to disclose over specific horizons to 2030, and to sort of put down what they're doing in this space. So the financial services that they're providing, any products that they're bringing to market, like green bonds, voting rights, all these kind of things that trigger requirements around net zero targets. And that is mandatory. So we are seeing, I genuinely think this is a direction of travel. And arguably, I would say the advent of transition planning regulation could and should sort of radically alter the landscape of greenwashing and supply chain concerns that are beginning to bubble up now. And I think also bring heightened attention to the role of finance sector actors, especially banks, in the net zero transition. Certainly one of the ways I think to reduce the risk of greenwashing, I attended, Paul was there too, on Monday, a corporate climate litigation conference, which was fantastic, really good. But there were a lot of, it was very much for corporate attendees, and there are lots of questions from the audience, you know, how can we reduce our risk of being sued for greenwashing? And so there's a real easy answer to that question. Anyway, yeah, how to reduce that risk of greenwashing litigation or other adjudicatory actions in your firm is not only to not greenwash, but also to get a credible, properly considered transition plan. Right? Develop it, take the hard work and time to do that, and then communicate it and then follow it. So I think greenwashing presents a litigation risk, obviously, to a firm, but it also presents broader risks to properly functioning markets and to market integrity. And those things trigger off the mandate of market regulators like the FCA, the Financial Conduct Authority. So it sits squarely on their menu of things to do. But also, I think greenwashing does present serious implications for achieving a net zero transition, just simply due to the potential it has for investment misalignment due to incorrect information. We're all busy investing in things that we think are green. We're doing our bit for the net zero transition. We're on our way. It's going to happen. And then it turns out, well, no, actually, that wasn't happening at all. So for these reasons, you know, greenwashing really, I think, masks a deeper problem of this issue around transition plan. And as colleagues at Columbia Centre on Sustainable Investment have pointed out, in response to the recent KLM decision, the greenwashing airline decision, they pointed out the answer doesn't lie in regulating or even stopping advertising, right? I mean, that's a lever only. It's a spotlight. We're shining on something. It's not the answer, though. The answer lies in the hard work of developing and communicating rigorous transition pathways. So I think the same logic there applies to supply chains, supply chain due diligence. So, for example, Mark mentioned this notion of a downstream client. And certainly if we're looking at banks, so downstream clients of banks have been omitted from the in progress corporate sustainability due diligence directive coming out of Europe, which will capture both European and non-European bigs, like the biggest firms now, the kind of reforms that have, or revisions that were just recently made, literally 7 days ago. Maybe only the biggest big, but nonetheless, bank clients are sort of omitted from that downstream nature of the supply chain, which is kind of crazy because financial sector actors generally don't have big emissions. They're not big on scope 1 and scope 2 emissions. Their contribution to both facilitating net zero and not is through their relationships. They are service-oriented entities. They are relational entities, and particularly, obviously, they're carbon-intensive clients. So their contribution is really going to be through their scope 3 emissions. And certainly, I think that the Milieu de Francais in the Shell case, the 2021 Dutch case, used 150% on appeal by Shell, but was successful in its moment, gives us a direction of travel here. And even though that was against a fossil fuel company and the financial services company, I think the logic of it regarding scope 3 still holds for other types of companies. It's something, particularly banks and also financial institutions. The logic of it being something that Frank Elderson of the European Central Bank called, a corporation's duty to do fair share, to do its fair share to reduce global greenhouse gas emissions. So I think that is going to come more and more to the fore through the lens of transition planning. And we'll speak to some of those advisory things also, Mark, that you were talking about. As lawyers, we advise banks, advising clients. Advising carbon-intensive clients to transition is often put forward as a really valid thing, particularly for a financial service actor like a bank to do. Lawyers could make the same argument, and why not? More and more I'm becoming a fan of transition finance, I must admit. But at what point do you actually say, these are just words? This is just business as usual in disguise. I think we're going to have to start needing metrics and accountability mechanisms around those kind of advisory claims as well. And there are sort of new principles, for want of a better word, in circulation, that zero for professional service providers sort of initiative that's floating around. It's contentious, but I think, again, it's a space to watch the potential influence of advisors on emissions reductions through their advisory work. And I think on transition plans, another important piece of that puzzle is, so far, a lot of the focus has been on the corporate sector. But we really do need equal attention to transition planning from the government and national levels as well. And we need that because it's at that national level that you get legal, regulatory and policy coherence and coordination. We certainly can ask central banks and financial regulators to have the ways to take a more sort of leading role in this space, but at the end of the day, they only have responsibility for their realm. They don't have responsibility for the transport sector. They don't have responsibility for energy. And if you want all the parts speaking to each other, and they all have to be speaking to each other, there will come a point where they all have to be speaking to each other. If we're heading in the same direction, toward net zero, then that level of cohesion and coordination needs to come from a national transition plan. And I must admit, I'm doing some really exciting work with colleagues from Columbia and Viva and LSE as well, who on that issue. That sort of how do you integrate bottom up corporate financial institution transition plans with top down national government transition plans, so that you have an integrated, coherent, coordinated regulatory approach to net zero transition. The other points I want to make that I think are actually kind of the cool points, but let's see if I can come back to them during questions. Let's leave it there for a second.
Thank you so much, Megan. So look, thank you all the panel already for the first tour. I'm looking here at the clock, and it's we have half an hour until that new end that I proposed, and I would love to open to questions. I have my own questions, but maybe we have questions. I don't know, Tiff, if we have online.
Yeah, we have 2 online.
Yeah. Shall we give the online people some advantage in stating their questions first? I would love to get more questions from you as well. So we'll start with the online and then I'll go to you. Tiff.
Can you hear me all right from over there? Do I need the mics?
Yeah.
All good? Yeah. So this is a question from Jack Eastwood, and I think it would be for maybe pension funds relevant discussion. So we've talked of financial materiality and its nexus to relevant considerations when talking of fiduciary duties of pension funds. New reporting standards, i.e. the CSRD, the reporting directive, are requiring consideration of impact materiality. There is an emphasis in these reporting standards that impacts often, if not always, crystallize into financial risk or opportunities. What are the time horizons that financial advisors, such as pension companies, must consider for the purpose of their fiduciary duties? Do you think that there is or will be a shift in the time horizons that must be considered in the longer term, to the longer term? That's the first.
Yeah, if you want to read the second one, and then we can compile.
Yes. So there's a question for Paul in terms of the ClientEarth and Shell directors case. So in terms of law reform, what lesson would you take from that case? Change the Companies Act 2006 or change judges?
I like the premise of the question immediately.
And then there is also a related one on that same case from another attendee. So most criticism of that judgment has ignored high authority cited in the judgment on how the duties are discharged and cherry-picked lower authorities to support a narrative of what they think the duty is or should be. The fact that it fell at the first hurdle must intuitively tell us that the judgment is not that beyond the bounds of reasonableness, and the claim itself was not necessarily rigorous. In any case, it was never going to get over the second hurdle as reported, so I thought I would give you an opportunity to respond to this comment.
And that question is from David Gibbs, perhaps?
Yes. But there are a few others, but they're on different topics, so maybe let's take those 2 first.
Yeah.
Yes, by all means.
Yeah.
So on the first question, I think it is an interesting question. I think there was scope for the courts to interpret the duties rather more flexibly than it did. I think it's worth setting out for the benefit of everyone in the audience who's not familiar. There is an initiative called the Better Business Act, which has attracted some quite widespread support really from business, from politicians, and one of the aims of that act is to, I think probably in the initiative's own words, to move some of the focus, some of the clear focus away from shareholder value or immediate short-term shareholder value towards perhaps a more expansive view of what companies should be doing in the 21st century. Now, I don't have any firm views on the nature of the reform. I think from my perspective, the the current version of Section 172 and 174, and I don't speak to the wider initiative of the Better Business Act, which I think certainly is laudable. But I think that the current scope of the duties under 172 and 174 lend themselves to a claim like ours. And certainly, as I suggested, there was scope there for those duties to be interpreted more flexibly. I think focusing in a little bit for the lawyers under 172, for example, directors shall have regard to the long-term consequences of the decisions that they take. I think this is an area in which you couldn't really be looking at any more sort of long-term consequences of decisions that they take, because the decisions that they take now in response to massive existential risk, really, for a lot of these high-emitting companies, will have ramifications for those companies, not just in the immediate term, but very clearly in the medium to long term. And that's, of course, why a lot of the institutional investors, pension funds, certainly, who are looking to that longer term perspective in the interest of their beneficiaries, but also asset managers, came along and actually supported our claim and said, look, aside from ClientEarth's charitable objectives, which they may or may not think are laudable, we are interested in the financial value of our portfolio, and that is why we explicitly support this litigation as shareholders of Shell. And indeed, we had over $500 billion in assets under management cumulatively, or owned by those investors supporting the claim, which was rather unprecedented. Litigation is something that traditional investors have not been particularly willing to go that far in their escalation. David, of course, has propagated his views on the claim widely, and of course we've engaged with David previously on those. I think David and I certainly depart very clearly on the merits of the claim, and I think it's interesting to note that, of course, as I mentioned at the outset, we're not the only ones, if you like, with a strong view of the merits of the claim and the way in which it was handled by Mr. Justice Trower. And I think it's worth just adding there that we are extremely fortunate in the jurisdiction of England and Wales to have an intellectually rigorous and a fair judiciary. That doesn't mean to say that, of course, judges cannot on occasion get it wrong, and we felt that this was such a case. Of course, fully respect David's views on the lines of authority. I think certainly there was authority going the other way on many of the points that were at issue and in dispute. And it was interesting to see the judge, I think, find for Shell on points which, in fact, Shell had not made as part of its defence, and without wanting to get too intricate into the detail of the case. One of those, for example, was that look, the court has to have regard to many other competing considerations that the directors might have to take into account when dealing with climate risk, and that was one of the findings of Mr. Justice Trower in the High Court. Now, that was a case that was never actually run by Shell. And our answer to that would have been, well, presumably they took those competing considerations into account when they were setting their transition strategy. The difficulty really from our perspective was that they had a transition strategy which sought to achieve certain objectives over here, and then the means and targets which they had adopted to achieve their own strategy, presumably set in the interest of the company, completely departed from those objectives. And so that was the basis of the claim. And unless there's anything further on the intricacies of the judgment, I'll pause there to allow perhaps a response to the very good pension question.
Sure. Thank you. So there was quite a lot in that first question to sort of unpack, but I think at its heart was the extent to which the external impact that your investments are having on the environmental biodiversity or anything else, the extent to which trustees have duties in respect to that external impact. There's a few things here. There's new regulations coming in under the sustainable disclosure rules, which do not apply to trust-based schemes. They apply to FCA regulated entities. Trust-based schemes are not in that space. That's contract-based. So at the moment, the whole SDR regime does not touch trust-based pension schemes. At some point, it may filter through, but at this stage, we're not there. Trustees of occupational schemes do have other disclosure requirements. Most notably, they have TCFD reporting requirements if their fund is over a certain size, and have to report carbon footprint and scope 1, scope 2 emissions, and more recently scope 3, and some other fund-related metrics. So I know that's not quite a question that's being asked, but trustees do have some reporting obligations on the statutory footing which they have to meet. I think it's entirely possible that the direction of travel will be to load more onto that, to use that TCFD reporting framework that pension trustees have to comply with and make it publicly available. You will see, you can go and look at all pension funds that are in scope. You can go and look at their TCFD reports. The data is dreadful, by the way, and the scenario analysis is even worse, which might bring us on to a question about the risk of trustees being sued. But so that kind of reporting of some external impacts is already there in relation to climate. It is not there yet in relation to other areas, but I think we could start to see some biodiversity or other sort of SDR related metrics being added on to the trustee reporting obligation. However, as I said, that regulatory environment that's applying to trustees is a reporting obligation only. The extent to which trustees have to take or can or should take the external impact of their investments into account in their investment decision making goes right back to those fiduciary duties I talked about before. You have to demonstrate that external impact is of financial relevance to you as the investor, the person holding those assets. I did a piece of work with the Impact Investing Institute where we did our very best to draw that link. So, of course, if you work on a philosophy that companies that are externalizing their costs are going to come a cropper from a regulatory point of view or suffer sort of transition risk, then that's a financial argument why you take that into account. So that's not because the external impact is your fiduciary duty. It's because the effect of that negative external impact will come back to bite that investment, and therefore it's a financial material factor to take into account. Conversely, those companies that have a positive external impact, there are plenty of impact funds and the like, you can take a view that they ought to be a better financial proposition. You can also start to draw some clever arguments together to say holding assets which have a positive external impact might, even if they have a potentially sort of lower than market return to comparable investments or even a potentially higher risk, it's still a sensible thing to hold because they act as a risk mitigant when you look at different climate scenarios. So I think there's other reasons that trustees can kind of look favourably from a financial point of view on funds that have positive impact. So there's plenty of arguments that can be drawn there, and there is, as I say, there is an impact investing institute paper on how impact investment is compatible with fiduciary duties. The point where we get the point we sort of get to the edge there is the point I made earlier around systemic risk. There's a very good argument to say that taking external impacts into account helps to address systemic risk, and therefore that's something that any investor should be doing. But trying to draw that link still feels that we're sort of at the edges of fiduciary duty at the moment. That's something I'd like to see sort of maybe some regulatory developments. But anyway, that's where we are.
It should be like a new principle, not the polluter pays, but the investor that is paying the polluter principle, something like this.
Yeah, so I always talk about it's the prisoner's dilemma, isn't it? If everyone just looks at the narrow investments that they have that are externalizing all of their costs, and that's damaging the market in which they're investing, that's a sort of net loss to everyone. That feels like that's sort of where we are at the moment, and that's something that I think needs to be addressed. But yeah, it's very difficult to sort of do that as a lone trustee board when you're only looking after 1.5 billion of assets. if you're a Nordic fund, by the way, you know, at 300 billion or whatever, you can regard yourself as a universal owner of the market and you can do all sorts of things, but that tends not to be the case.
Thank you. Can I invite anyone sitting here to ask questions? Kate.
Thanks, everybody. This has been really interesting. And I have to say, Stuart, I want to stick with the pensions question because it's very fascinating.
Right today.
I disagree with the question, the statement, it's not sexy, but my question is, in the US, we've recently seen a case, Wong and the New York City retirement system, where the pension fund trustees are being challenged because they think that ESG factors are financially material. And I'm curious for your views on that case and curious about whether you think there's any possibility of such a claim taking place here, or whether you think the regulatory environment is such that it just would be thrown out.
It's the political thing. So actually, when you sort of boil it down to the duties, they're not particularly dissimilar, those fiduciary duties. So in the US, I'm not a US lawyer, and I'm definitely not a US lawyer. I mean, I've niched myself to a point of knowing a lot about almost nothing at all in UK pension funds. But the sort of basic concept, so they talk about pecuniary factors rather than financially material factors. There is, you know, there has in the US, certainly in the last presidency, and maybe in the next one, a sort of strong pressure against ESG factors on a sort of political understanding that ESG means non-pecuniary. And that's a fundamental mindset difference here. Here we've got the Law Commission in 2014 saying ESG should be considered as a financially material factor. FMLC, absolutely, you know, if you're not considering it as a financially material factor, you're doing something wrong. So I think that's the difference. It's not that the legal duties are any different. It's just the mindset there is ESG sort of almost has a different connotation of being what we might sort of talk about when we talk about non-financial factors of ethical or moral viewpoints. So, you know, what's the phrase? Is sort of, you know, two countries separated by a common language. I think that's sort of the issue we have there. I wouldn't really like to comment on the US pension system because that's quite different as well. But I don't think there is a risk here of trustees being told they're doing too much. And sorry, this is a bit which I was probably being recorded, so I would ask you sort of certainly not to quote on it, but when we have trustees that are looking to be sort of quite progressive in terms of their how they're approaching climate issues, and they'll always ask me, so, you know, what can we do within our fiduciary duties? There's always the side message that says, if you go a bit too far, so you sort of act on systemic risk in a way that we think is sort of maybe slightly over your fiduciary duty of current understanding. Honestly, what's the risk? If you're a defined benefit scheme and your sponsor has said, you've consulted with your sponsor about how it said that the employer, the one that's funding the thing, they said they're okay with it. Your members are still getting the same level of pensions. You've got to be a pretty particular type of member that says, I'm going to sue my trustees for doing too much on the environment, even though it doesn't affect my pension. And the sponsor said they haven't fund it. So I think, I mean, I've talked about, as I say, I think because of the structure and, well, you know, might talk about a bit more, but the trustees are sort of quite insulated in their investment decision making, and they take advice, and they're sort of very heavily protected as long as they followed advice and not misdirected themselves and all those other things. Yeah, I think the chances of us having that sort of US litigation very, very low here, and I know that's, you know, that's a good thing. I think trustees are, on the whole, sort of really engaging with this topic in a way that probably isn't happening sort of globally. The UK pension system is probably a little bit ahead in terms of thinking about that. As I say, maybe some of the Nordics are a bit different.
Can I ask a question?
Yes.
There's no other hands at the moment. And I think it's I want to bring Mark into concept and Paul and Ivano as well. So when Paul was initially speaking, he mentioned the Smith and Setzer case, the New Zealand case. We also have Milieu, Bronstein, Michelle case in the Netherlands. You know, cases that are not same as, but you know, perhaps commensurable with the ClientEarth and Michelle case themselves here in the UK, with wildly different outcomes. And I'm just interested in the relevance of jurisdictional context in this realm. Now we are, you know, sort of focused on the UK chapter, I understand that, but it's impossible, I think, to have this discussion without a comparative lens at some moment. So I guess this is the moment. And I'm just wondering, yeah, maybe Paul, you want to raise those points, but I'd like to meet Mark and Ivano, who's had overview of the project as well, about, you know, what does that mean in this space?
Yeah, of course. Thanks, Megan. And I should say immediately that I'd just like, before I answer your question, to throw my voice behind, I think, pretty much everything you said in your overview. I think if I found myself nodding along any more vigorously, I probably would have given myself neck ache. But to answer your question, you're right. There has been a divergence of approach. And it's interesting, I think, particularly as an English qualified lawyer, obviously, to see that divergence in the common law jurisdictions. And you're right to say that our claim against Charles Ward and the Smith-Montero litigation are, in a sense, very different. On the other hand, they're both relatively novel, and I'm sure David would agree with this one. I'm relatively novel, relatively unprecedented types of claim. And the courts did ultimately, albeit at the Supreme Court level in New Zealand, it had to get to that level. The Court of Appeal struck out the claim entirely in New Zealand. But the Supreme Court in New Zealand and the High Court in England, and of course the Court of Appeal in its decision to refuse us permission to appeal, took quite different approaches. The New Zealand Supreme Court effectively said, and it's quite poetic and lyrical, that claims of this nature should not founder on the barren rocks of a strikeout sort of early stage elimination, but rather should be assessed in the fertile grounds of trial. And that's certainly, of course, our view in our claim in England. And the view of the New Zealand Supreme Court seemed very much that common law should take that sort of, in a sense, one of the advantages of common law, that it is flexible and responsive to the changing societal expectations and demands, and that these claims should sort of be tested and examined. Obviously, the UK court in our case took a different approach. That may be a function of you know, one or two particular judicial perspectives on the nature of the claim and the supporting evidence and so on. And it was interesting, of course, to see Lord Carnwath saying that a different judge, even in the UK, could have taken a different view on merits of the claim. So I'm very wary of suggesting in any way that it's sort of pot luck, because that's clearly not the case. But I think we will see perhaps certain jurisdictions. I mean, the Netherlands has a reputation in a sense already for being rather less restrictive and looking at these claims in a more expansive way. We saw that, of course, with the Milieu de Shell outcome, and recently last week with the greenwashing decision against KLM, which ClientEarth supported. But Mark, perhaps your view would be really interesting.
I mean, as far as the ClientEarth derivative claim is concerned, the comments made by Lord Carnwath in his critique of that decision are really quite powerful, I think, and anybody who's kind of interested in the merits of it should read that, because I think it shows that, okay, Mr. Justice Troutner came to one view, but many other judges might have come to the opposite view and at least granted permission. Whether you win on the substantive is another matter, but the case should have been heard at a substantive level. At least that's his view, and I think that I would concur with it, having read the critique. The point about the Smith-Montero case and others of this ilk in other comparative jurisdictions is that I think that reading the, you know, from a lawyer's point of view, reading the claim, reading the way in which it's presented, again, gives me food for thought. You know, it makes me think, right, we can perhaps think about doing that here. And I think that giving the claimant in that case permission, as the Supreme Court in New Zealand did, to have their case heard in a substantive hearing, to go through to trial. I think will give judges in this jurisdiction and others the confidence to perhaps take similar decisions in cases that we might bring in this jurisdiction. I think the same can be said about the cases we brought challenging EIAs and the failure to take downstream emissions. Although I have to say, we looked very hard to see whether another case had been brought on that basis, and there were very few in the whole of the EU, but there were some obviously in the US and Australia. And so, putting that comparative law in front of, for example, UK judges gives them the confidence to think, well, actually, I'm not going to be completely out on a limb here if I accede to this argument. In fact, there's logic, and it's clear, and it's well reasoned in the judgment, as I said, for example, of Chief Justice Brian Preston, in one of the cases we put before the Supreme Court. The fact is, the Gloucester mining case. The fact is that these judges have thought about it. They're further forward in terms of the progression of the cases than we are. Perhaps the Australian lawyers are more more inventive, more litigious, but they've and they've got judges in an environmental court. That's a stage further than we've got so far. And so I think it's really important that we understand this. It's a global issue. It's a global climate emergency, and judges around the world are grappling with the issue. And some are being much more progressive than others. You gave the example of the Netherlands, and it's a very good one. But we should learn from that and not feel that as if we know everything and that we have to be constrained by the tools of old that we have grown up learning about in Winfield and John's book. That's the old book I've got on a shelf in my room, and it's probably 20 years out of date. The fact is, we can create new tools. That's why I'm interested in the animals, and that's possibly being the new claimants. Who knows, with somebody advancing their case. It's just something that I think that we can, we should be thinking outside the box, and comparative law that we can rest upon, I think will give judges here the confidence to move the dial and move forward with the times.
If I can start from this, I completely agree with Mark, and I think that in a way, something that now is necessary, also considering that this is really an important part of our global climate governance, which is not just restricted to wait every year at COP what they're going to do and cry. So it's really important. Yeah. And I think that in a way, this kind of exercise that Mark is talking about is what we like to talk the bricolage juridique. So this idea of creating something new with something old that we already have, but we can only do that if we are a little bit free from our, from our conditioning that they say, okay, the judges decided like this, and so it's not. We know very well that a decision can be reversed. Some scholarship can influence the doctrine can change. And especially, the case that Mark mentioned, the Rocky Hill case, the Gloucester mine, that is really something that for me was, I used also during my course at university, because I think that it's important that students understand that if Brian Preston, that for me is a hero, but there are many Brian Preston, unfortunately always more, and if he used in his decision also talking about other decision, the Urgenda case, the Gary case, the one in the German. I mean, this is really something that makes us be hopeful for the future. So what are the perspectives? And I think this dialogue between the judiciary through decisions that take into consideration other ratio decidendi or just other decisions is really fundamental. So in a way, this is really the platform where we are working on together, trying to share our experience, our ideas. We just have to do one effort that is not to restrict ourselves to think that law is like this. Law for me is not a science. Law is art. We create law. We can do it together. We just have to find the good reasoning. We have to do it together, and we have to learn from each other. So that's why on the Global Toolbox, we really had this comparative workshop. And for me, the US rapporteur has the same amount of experience to provide that the one from Nigeria, from China, from Japan. For me, sometimes you find the most interesting idea where you wouldn't imagine, because now, you know, Sabine Center shows us that most of the cases are coming from there. So we say, okay, let's see at the US. But then you just see some comparative analysis. For example, this morning we had the chance of listening to Professor Autoro Boutonnet from France, and she told us that actually she did this comparison last year with Dan Hasty from Yale, and they say, okay, you in the US, you have all these wonderful cases, how many victories? In France, we have 2 cases at that point, how many victories? So, you know, this is also important to see. And even though, just to finish, even about the victories, is also this the problem. And the good thing about corporate crime litigation is the strategic side of corporate crime litigation. What Megan said, what Joana always wrote about, is important corporate crime litigation in general, even though we are not succeeding, because anyway, it's not that the goal. The goal is to make sure that the companies change the behavior, and as soon as possible, because we don't have time. So yeah, this is yeah, please.
Yeah, no, it's just that there was a question, I think, just on that last point you mentioned, which raised the Millie DeFonsi and Shell case, which I think has mentioned quite a lot today. Specifically that Shell has yet to obey the orders of the Dutch court and has emitted more greenhouse gas emissions. Does this show that the law is overstretched? Like what can human rights law do about this? That was one of the, I think that which bounces on what you just said. So I wanted to raise this question from.
Yeah, I think that we have an important tool at our disposal now that is human rights, that we can see how to use it. But we have also to consider that each legal system is going to use in a different way. I mean, we are talking about something that is international, so should be for everyone, but we don't have yet, and it is something that I would hope to see in the future, a pact, you know, a global pact for the environment, as we try to, with the, you know, human rights principles. So until then, what we have to do is to try and deal with what our judges can do. And our judges sometimes are like the Dutch judges. Sometimes they are like the Italian ones, you see? The Giudizio Universale crashed it out because oh, no jurisdiction, not even thinking about all the implications this kind of decision will have. And we'll see for any case, because now we have the case against any brought by Greenpeace and Recommon, and the case, the slap lawsuits from Greenpeace and Recommon against them. So it's a very composite kind of framework, and I think that we have to just try, if we can do something, you know, academics and practitioners together, is just to discuss and trying to find the right arguments to see, you see, to show to the judges, you see, is something that exists, and we can take advantage also of the experience of other countries. For me, it's always that human rights can be also an important tool. This morning we had David Boyd doing these opening remarks, and of course, introducing some very compelling arguments that you cannot say, you know, real stuff. So yeah, in a way, this is my answer to this. Yeah, what do you think?
It was a very, I think, inspiring towards the end of this conversation to hear from you. And
Sorry, I monopolized.
No, I think it was very good, and I guess also it speaks a lot what the tool is about, right? And I have actually one question: how are you updating this now? Because it's an area that never stops changing.
Yeah.
How are you going to keep it up to date?
So at this point, we have more than 200 people, you included, that are working with us. Yeah, we have the toolbox is structured in a way that we have the rapporteurs, which are our contact point. They are people that really wrote, like Kim Bouwer, these reports, and they provide us something because, of course, we count on them, we pay them. We can say, and then we have all this group of people, the international expert group, that are practitioners, judges, scientists, hopefully always more economists also, because we need also that. And in a way, what we are going to do in the next steps is to keep updating with the new cases, with the new work on that. As I said, during the different regional summit, we are going to include new countries, but it's not that the country that finished the work They haven't finished anything. This is just the beginning. So we will keep, engaging them into the next phases. And the idea is that this section that at this point you can already see on our website since this morning will be improved and will be an evolution. And so periodically, I don't know, it depends also on our strength. Could be every few weeks. I see my colleagues right bigger. It depends our strength. It could be every few weeks, every month. The idea is to have something that next year, for example, we are going to focus on absolutely director duties, greenwashing, probably this point of the pension funds, if you think it might be interesting. Standing another topic that are really important to push a little bit more. So we are going to work with everyone. And of course, this is also an invite to everyone present here. If you want to join us, this is a collaborative platform, evolutive or evolutionary. I think from my English, evolutive, it sounds much better, but I could be wrong. And yeah, the idea is that we continue to update. So if you want to join us, you have my contact. There is Jane Cloak, that is the beautiful lady there that doesn't want to appear. And we try to, we mentioned, and we try to keep working on this and updating as much as we can with the big discussion. And yeah, thank you very much, everyone.
So Mark, you see, you're right. It might be like Star Wars. There will be many follow-ups. So look, I want to thank so much this panel. It was amazing. So make two invitations for two next events that we'll have here at LSE. On the 24th of April, we'll have Lord Carnwath, who not only wrote that fascinating note about the ClientEarth case, but also will be speaking now here in this event about the Climate Change Act in the UK, with Lord Deben, with Ruchi from Queenstone, and
Alina.
And Alina Virchinkova, our own GRI colleague. So analyzing the UK Climate Act from the several perspectives of the Climate Change Committee, the law, the litigation, 24th of April. And then, of course, 27th of June, the launch of the 2024 Global Trends in Climate Litigation. Kate Hyam and I will be again running our show and hoping that the 2024 report will be able to capture this very rich field. So it's a big challenge, but we also always thank you all for helping us to think through the report and give feedback and come to our launch on the 27th of June. So 2 dates for your diaries. And then really, again, I want to thank Kim Bouwer and say we really missed you. Thank you, Kim, for your hard work, for organizing this. To Tiff and to Shirinas and everyone else at LSE GRI for organizing events. It's always hard work. Thank you to the audience who came, and special thanks to all of you who shared so many insightful thoughts. Really enjoyed, and we finished still a bit before. I think we have time here to chat for those who are in the room, which I think also is what I was hoping for, to have a chance to have an interaction, continuing interaction with those who are here. And I hope to see you in our next events, and in the maybe reconvening around the toolbox when we'll see the successful future ClientEarth case, the case that Mark will bring with his new vision of corporate law, the pension fund case, and even writing and
Watching the break later. And thank you, Joana, for your
Good. Tiff, online people, goodbye. Good, yeah.